And the last sentence of that second to last paragraph, Mr. Cheshire indicates he has fully cooperated, meaning Mr. Evans has fully cooperated in the police investigation and is ready to continue to cooperate by speaking to you personally about the events of that night and answering any follow-up questions you may have as you are considering the evidence in your charging decision. See
yes.
That? And what's the last sentence Mr. Cheshire puts in that letter?
I just wanted you to know that David and I are ready to meet with you at your convenience as you make decisions that could significantly affect the rest of his life.
His life meaning Mr. Evans?
Yes.
And did Mr. Nifong take Mr. Cheshire up on the offer to speak personally with David Evans about the events of that night and answer any follow-up questions before he made a decision?
No, he didn't.
The following week, did you receive reports from the SBI concerning their serology and DNA testing?
Yes.
Did you receive anything from Mr. Nifong concerning those results prior to the written reports?
No.
You were here yesterday and heard Agent Lynn testify about conversations that she had with Mr. Nifong prior to April 10th. Were you here for that?
Yes.
And did you ever receive any information from Mr. Nifong between the conversation that she testified to on March 30th and when you received the written report on April 10th?
No.
Can you look at Exhibit 209 and identify that for me, please?
Yes, Exhibit number 209 is the final report, I believe, of the SBI lab regarding its some of its forensic analysis in this case.
Okay. And we've heard testimony about the substance of that report, so I won't ask you about that, but I do want to ask you what the reaction was of you and the other defense lawyers upon receiving these SBI reports.
Well, we weren't surprised at what the results were because the results clearly reflected that there was no DNA from any of the lacrosse players that was identified on any of the rape kit items. It was, you know, we had heard a lot in the media from Mr. Nifong, and we had read a lot in pleadings from the state of North Carolina about how DNA test results would be critical to the case and how charging decisions weren't going to be made until the DNA test results came back, and about how DNA test results would clear the innocent. So we were very, very happy to receive a report that essentially showed that there was no DNA match between Ms. Mangum and any of these players. And we were also very, very anxious because of those comments that had been made to communicate the substance of these results to the people to whom the comments had been made, which was the public.
Okay. And did you or the other defense counsel in the case take any action with respect to these reports after you received them?
Yes, there were a number of different attorneys involved in the case at this point in time, representing different people. And we all collectively met with each other, and we discussed, as you know, Mr. Cheshire and I had already discussed issues related to public comments that the defendants were entitled to make as a result of the media attention that had followed Mr. Nifong's comments. We discussed some of those issues again, and we decided that we needed to announce these results to the public for a number of different reasons. Number one, so that they would know the truth about what these results were. And number two, because it was incumbent upon us to do everything that we could do legally and ethically to try to fend off what we all believed and knew to be a wrongful indictment of any of these young people. So what we did is we talked about the types of things that we were going to say, and we decided and agreed, and he agreed that Mr. Smith, Wade Smith, would speak preliminarily, and we all went to the Durham County Courthouse and announced these results and took questions from the media about them.
And after that conference or the discussions with the media, did you hear Mr. Nifong make any subsequent comments about whether he intended to move forward with this case or with this investigation?
Yes, he went to forum at North Carolina Central University the next day, which incidentally, the day that we received this test result was April the 10th. And it was the same day that he first met with Dr. Meehan at DNA Security and was told that they found a bunch of DNA on the rape kit items that did not match any of the lacrosse players. And the next day, he went to a public forum at North Carolina Central University and told the people there that he was there to assure them that the case was not going away, and that I believe his comments along those lines were, just because there's no DNA doesn't mean nothing happened. It just means nothing was left behind. Nothing was found.
And you said that forum was on April 11th, 2006?
Yes.
And that was the day after the first meeting with Dr. Meehan?
Yes. In which he learned that there was plenty of DNA that had been left behind.
Did Mr. Nifong ever respond to the letters that you, Mr. Cheshire, and the other defense lawyers had sent about the non-testimonial order?
Yes, he did.
Can you look at Exhibit 211, please?
Yes.
Can you identify what that is?
This is a fax that was, I'm not sure if this is the version that was received by our office, but it was sent to our office along with a number of other different attorneys involved in the case from Mr. Nifong. About those requests for information obtained as a result of the non-testimonial identification order.
All right. And can you read the last paragraph that Mr. Nifong writes in that letter, please?
I am aware of my duties to furnish copies of any such reports to you under GS 15-282, and as was the case with the SBI lab reports, I intend to furnish those reports to you immediately upon my receipt of them. At this time, I do not anticipate receiving any such reports before the week of April the 17th.
Mr. Nifong then was notifying you and the other defense counsel that he understood his obligations under the non-testimonial order statute?
Yes.
After you received that, and what was he referring to as far as the testing in this particular letter? This April 12th letter, was it the DNA or some other testing?
He was referring to the reports of any photo identification procedures because a number of us, I believe at the April 11th forum, some of Mr. Nifong's comments related to, well, what if I assume that no one had identified an attacker until last week, or something along those lines. And so I think that some of the attorneys involved were renewing requests and anxious to get information. You know, if someone has identified an attacker pursuant to photographic procedures that you're talking about publicly that happened last week, then, you know, we'd like those results under the law because we're entitled to them.
Okay. And that, do you know now when that photographic identification procedure was?
It was April 4th, which would have been, I think, 8 days before this fax was sent. All right.
Did you or Mr. Cheshire send Mr. Nifong another letter later that month?
Yes.
Can you look at Exhibit 213, please?
Okay.
And what's the date on that letter?
April the 28th of 2006.
That's after Colin Finnerty and Reed Seligman have been indicted?
Yes.
In this letter, do you make any request for additional DNA or forensic testing in this case?
Yes.
And where is that in the letter? Do you know?
It's in the second paragraph of the letter.
Had you received any information from Mr. Nifong as of April 28th about the results of any testing from DNA Security?
No.
And this was after the first two meetings with Dr. Meehan that Mr. Nifong had?
Yes. I think the last meeting before this letter was on April 21st, where I think Dr. Meehan had said, I can give you the report that you're requesting, but Mr. Nifong apparently said he didn't need a report at that time.
All right. Can you read it?